Hi, this is Irina Shea, and this is part of our Wealth and Wisdom video series. Today, we're going to talk about estate planning for unmarried partners. So, I'm going to share my screen with some thoughts. Um, Increasingly, there are couples who are, it's for couples who are together, but not married, not civil union, so no legal status there, and may or may not live together. So we're seeing an uptick in sort of unconventional couples, we'll call it, due to gray divorce, due to longevity overall, or someone was widowed or widower young and they repartner, but they may not want to be legally bound to this person, but they want to provide for this person if they pass away first. So, how do we handle this? There's a few thoughts I have. First of all, you have to be very careful about the New Jersey inheritance tax on the unmarried partner. They are going to be anything left to that unmarried partner is subject to roughly a 16% New Jersey inheritance tax because you're not married to them and you don't have civil union status. They are classified simply as a friend legally. So, how do you possibly leave money to them? One way is life insurance, which is exempt from this tax. But if you are older, but if older, that is not really going to be financially feasible as premiums skyrocket. So just by getting older, right? And no other reason. Also, sometimes you want a provision, if you live together, a provision to allow the life partner to live in a joint home, for example, a home you share and live in together for a period of time after death. Um, it's usually, it could be 6 months, it could be more, could 6 months to a year. Um, And another is sometimes couples now are not marrying, but buying a house together. Okay, so if they're buying a house together, this gets really tricky. That's when I suggest they do what I like to call a house nup. Somewhat of a prenup for the house because you have to discuss if you're each putting in $1 million to a $2 million house in Bergen County, what happens in the event of death, disability, etc., of one homeowner. You're not married, so it's going to likely end up with different beneficiaries. So often we see, I'll call it parallel estate plans in these cases where um, partner one leaves assets to their children, and partner two leaves assets to their children. And it just is parallels down the line, and they're not really leaving assets to one another. This works well where there is financial parity. Often, however, there is not. If P1, partner one, has lots more money than P2, we have to make sure P2 is not left, we'll call it high and dry in later years. So we may need to, right, may need to allocate funds and take the inheritance tax hit in order to provide something for that partner. Or we consider not dying in New Jersey if this is your situation. That is another possibility. Or consider marriage to avoid the tax. But then, but then there is a one-third right of election that creates, unless there's a prenup waiving it, unless prenup waiving, and it creates other obligations, creates other major financial obligations that may not be desired by by the two people. They just may not want that level of formality. So it's a delicate balance. You're trying to solve one problem without creating another. This is estate planning. But if you are in an unmarried partnership with someone that whether you live with them or you don't live with them, but you're planning long term to do life together, know that there are these nuances, at least here in New Jersey, to consider. And definitely see an estate planning attorney to make sure you can align as best you can one another's needs along with your separate children's needs. It's tricky territory, and you definitely want to talk to a specialist about this. So if you'd like to learn more, you can go to our website at irinashea.com. Just click on the Get Started tab, and there are no fees for our initial consultation. Thanks.